Good morning, good afternoon to everyone, and welcome to Mayor Brown's webinar titled GDPR Lessons Learned from the First 100 Days. My name is Ulrich Worm, and I'm a partner in Mayor Brown's Frankfurt office, heading the German IP and IT practice. Joining me today as my co-presenters are my colleagues Charles-Albert Helleput, Diletta De Chico, Oliver Jaros, Björn Vollmuth, and Lei Shen. Charles is a partner in our Brussels office, and he heads the Cybersecurity and Data Privacy Group in Brussels. Diletta is an associate, also situated in the Brussels office. She focuses on advising clients regarding a wide range of global data privacy and cybersecurity issues. Oliver is a partner in Mayor Brown's IP and IT Group of the London office, and a member of the Cybersecurity and Data Privacy and Technology Transactions practices. He advises clients on TNT, outsourcing, IT, data protection and privacy, e-commerce, and IP transactions. Björn serves as a counsel in Mayor Brown's employment and benefits practice in the Frankfurt office. He advises clients on individual and collective employment law matters and on data protection matters. And last but not least, Lei is a partner in our Chicago office, where she focuses her practice on cybersecurity and data privacy and technology transactions matters. She advises clients regarding a wide range of global data privacy and security issues. I will start off with giving a quick overview about news, developments, and first enforcement trends. Diletta and Charles will continue discussing lessons learned from data breaches. Björn and Oliver will discuss the challenges of negotiating data protection addenda, and Lei will discuss about new GDPR-inspired laws in California and Brazil. But before we begin, I'd like to mention a few organizational things. As noted under the FAQ widget on the right side of your screen, today's program is being streamed to your computer, so there is no dial-in number we provide to you. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presentation well. Regarding CLE credit, we will be providing an alphanumeric code during the presentation. In order to receive CLE credit, you must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. These forms are also available to download on the right-hand side of your screen under Resource List if you need them. With that said, let's get started with news, developments, and enforcement trends since GDPR date. We've got our teeth now, but we haven't shown our bite, to speak in the words of the head of the Data Protection Authority of the German state of Hessen. While it is always kind of difficult to translate idiomatic expressions like this one, I think what the sentence says is that while the data protection authorities have the power to impose severe fines, they don't intend to be overly aggressive. And indeed, only a limited number of fines have been reported since GDPR Day yet. To mention a few examples where fines have been imposed. The UK Data Protection Authority recently fined a company for selling data for political campaigning. In that case, a data broking company, which provides advice on pregnancy and childcare, sold information to another company which used that data for the benefit of the UK Labour Party. The Labour Party used that data to profile the new mums for the run-up to the 2017 UK general election. The Labour Party was then able to selectively target the new mums to win their vote in the election. That use of the personal data was not disclosed to the data subjects. As a result, the UK data protection authorities imposed a fine of £140,000 and found that due to the timing of certain incidents in this investigation, the fines had to be issued under the previous legislation, that is the UK Data Protection Act 1999, and not under the GDPR. In another case, the UK Data Protection Authority fined another company for sending emails to recipients without those recipients consenting to receive such emails. Again, the UK Data Protection Authority imposed a fine of £60,000 for violations of the UK privacy and electronic communications regulations, which are also known by its abbreviation PECA. Because the fines in both cases have been imposed under the old legal regime, no conclusions can yet be drawn as to the amount of fines which would have been imposed under GDPR in comparable cases. Further, the limited number of reported cases in which fines have been imposed since GDPR Day cannot lead to the conclusion that the data protection authorities are reluctant to impose fines, given that fine proceedings typically take time, and it will thus only be a matter of time until we will see fines being imposed under GDPR. And we will need to see what fines will then be typically imposed. What we can say right now is that the data protection authorities are still overwhelmed by GDPR, as most companies are. Several data protection authorities across Europe have reported that the number of complaints filed by data subjects, the number of requests for guidance, and the number of notifications of personal data breaches being reported to the data protection authorities have increased substantially. Depending on the data protection authority and the categories of notifications, those numbers have at least doubled, and in some cases the numbers have increased by a factor of 10 compared to pre-GDPR times. What this means is that the authorities need to staff up and they need to prioritize in order to tackle this and get their heads around GDPR. Further, statements from some of the data protection authorities throughout Europe and the general political climate suggest that the authorities will focus enforcement activities first on the big fish, work with recommendations and warnings before imposing fines against smaller players, and continue to issue guidance documents to help companies navigate GDPR. This, however, does not mean that data protection authorities will be reluctant to impose fines at this point in time. Rather, they don't fail to state that they will take enforcement actions, including the imposition of fines, if obligations under the GDPR are, quote, persistently ignored, unquote, to use the words of the UK Data Protection Authority. What else have we seen since GDPR Day? Data protection authorities have started to audit companies. To give a couple of examples, the Data Protection Authority of the German state of Niedersachsen has started to audit 50 companies from various sectors with the main objectives to raise awareness for the importance to become GDPR compliant and to gain insight into the challenges companies face with GDPR compliance. But similar to the UK Data Protection Authority, the German authority has also stressed that it would take enforcement actions against violations discovered in these investigations. Another German data protection authority has started to investigate several hospitals in relation to the handling of health data. Several German data protection authorities have investigated producers of fitness trackers, smartwatches, and other wearables, and reported substantial GDPR violations. The UK Data Protection Authority investigated companies who provide data analytics for political purposes, and this particular investigation has led to the first case discussed a few minutes ago, where the UK Data Protection Authority has imposed a fine for violations of applicable data protection rules. The Italian Data Protection Authority has recently announced that it will focus in the remainder of 2018 on processing activities carried out by public bodies which handle big databases, data protection measures implemented by financial institutions, and processing activities related to telephone marketing. The Italian authority has also said that its investigations in these fields will cover various aspects, including questions like whether data subjects have been sufficiently informed about the scope of the data processing, whether the requirements for valid consent or other legal basis on which the data processing is founded are met, whether data retention policies are in compliance with GDPR, whether sufficient security measures have been taken by the controllers and processors, whether appropriate data processing agreements have been put in place, and whether data protection officers have been appointed and notified to the Data Protection Authority. What else have we seen? Sadly, but not really surprisingly, we are seeing conflicting guidance from authorities across Europe. To give just one example, in the context of study agreements concerning pharmaceuticals and/or medical devices, the UK Health Research Authority took the position that hospitals are data processors of study sponsors. In contrast to this position, the German working group of the ethics commissions, which are involved in clinical studies, rather suggests that hospitals and study sponsors are typically joint controllers. What this little example shows is that conflicting guidance creates particular challenges for companies to develop a joint GDPR compliance strategy which works throughout Europe. There is no one-size-fits-all solution, and one needs to be aware of different legal positions taken by different data protection authorities in the relevant markets at the outset of developing a Europe-wide strategy. Also, sadly, but again not surprisingly, we have seen market participants sending out first cease and desist letters to competitors, arguing that a violation of GDPR obligations amounts to a violation of the German Act Against Unfair Competition. There is no reported case law yet on the question whether GDPR violations are actually actionable by competitors on this basis. If you look at the German legal commentators, they appear to be pretty split on this question. And while there are political initiatives to explicitly exclude GDPR violations from the German Act Against Unfair Competition, it will take some time before these initiatives will result in statutory law. While there have been fears that there would be huge numbers of cease and desist letters being sent right after GDPR Day, and that there would be law firms specializing on sending cease and desist letters based on GDPR violations, those fears have fortunately not materialized. The number of cease and desist letters we have seen thus far remains rather small. Still, this creates an additional layer of exposure for companies, as they are not only faced with data protection authorities who might investigate and enforce against them, but also with competitors who can use the vehicle of the German Act Against Unfair Competition to enforce the law in their own right. What we have also seen since GDPR Day is a lively discussion about the legitimacy of data transfers from Europe to third countries like the United States, which are perceived to provide less protection for personal data. The GDPR allows data transfers to third countries like the US if certain safeguards are met. Two of the possibilities to legitimately transfer data is the so-called EU-US Privacy Shield and the standard contractual clauses adopted by the European Commission. In relation to the Privacy Shield, the European Parliament adopted a resolution on 5 July 2018 and asked the EU Commission to suspend the Privacy Shield for reasons which are similar to those which had led to the nullification of the safe harbor rules, which were the predecessor of the Privacy Shield. While the resolution of the European Parliament is not binding on the European Commission, it shows that there is a lively political discussion about whether the Privacy Shield is an adequate legal basis for transferring data to third countries. Also, the Privacy Shield is subject to annual reviews. The next annual review is expected to take place in October 2018, and it remains to be seen what the outcome of that review will be. Meanwhile, the European Court of Justice has been asked by the Irish High Court to rule whether standard contractual clauses and the Privacy Shield remain valid legal bases for transferring data under the GDPR to third countries. This case has also become known as the Schrems 2.0 case, because the claimant in the underlying action is Mr. Schrems, a data protection activist, whose previous action led to the European Court of Justice nullify the safe harbor rules. All this means that data transfers to third countries will remain one of the most challenging aspects to navigate under GDPR. I will now hand over to Diletta De Chico and Charles Albert Helleput, who will discuss the even more challenging scenario of a data breach.
So not as a surprise, but breach have happened. They were notified to DPAs and even communicated to data subjects since GDPR Day. If you have looked into the 2017 Ponemon Institute report, you will have seen that experience a data breach is just something that all of us will have to live with, because data breach will indeed happen. What we saw for our clients so far is the kind of full spectrum of possible breach caused either by human errors, human misbehaviors, malwares, or very sophisticated and good phishing. We experience local, cross-border, or very truly global breaches involving both processors, controllers, or even both of them. In terms of magnitudes, we experience and saw pretty big or significant breach with millions of occurrence and data loss, but also really small ones. But it's probably fair to say that for each and every single of them, it has required some effort from our clients to adequately deal with it. We are not the only one having seen breaches happening. If you looked at, for example, some of the reports that DPA have been publishing, especially if you look at the one that ICO published, it mentioned that from a start of around 500 data breach notification in May, the figures then move up to around 1,700 breach report notification occurring and taking place in the month of June. So what did we learn from assisting our client in this area? Basically, we want to share with you today 5 lessons that we kind of learn by assisting our client. Let's first list them one by one, and of course, we'll come to them in just a little more details shortly after it. First lesson, which is probably a very important one, is that, of course, dealing with GDPR breaches is something you need to deal with and be aware of. But unfortunately, for many organizations, GDPR is only one aspect of data breach and security, and you also need to consider other frameworks. That's lesson 1. Lesson 2 is that in dealing with your DPA, so with your data protection authorities, of course, interaction is necessary, but you probably should interact only very carefully with those authorities, and we'll explain in a second why this is the case. A third lesson is that probably dealing with data breach is a lively test case for all of those who elected a lead supervisory authority. Lesson 4 is that even if ideally GDPR was supposed to bring harmonization across Europe, notifying DPAs on data breach might be uneasy, and will also cover in some details the reason for that. And lesson 5 is about the why, how, and when of communication to data subject, something that can cause some headache for organizations. And finally, we are also prepared to share some extra lessons, but you will discover that at the end of our presentation. So let's go with the first lesson. GDPR is not the only thing that matters. As a reminder, we all know that GDPR imposes strict compliance or requirements on organizations having to deal with personal data breach. We know that GDPR imposes tight deadlines and that organizations have invested a lot to be ready and to comply with those requirements if and where needed. But what we clearly learned is that GDPR is not the only framework or the only breach and security framework you have to deal with it or come into play. Others, prudential requirements or notification might apply to you, or even non-EU rules or regime might also be applicable. Another question or theme that we have seen happening is that, of course, dealing with the GDPR requirement and framework is necessary, but might sometimes have to be balanced with other regime or discussion, for example, with enforcement authorities. So really the key lesson there is that preparation and readiness of a global team to coordinate and work alongside is necessary if you want to protect the interests of your organization and mitigate possible exposures. Get prepared in advance with tabletop exercise that can just help to have everyone gathering and get allocated his or her role when the breach will happen is something that has proven to be very valuable. So lesson 2, indeed interact with your DPA with caution. As a reminder, transparency and accountability are important data protection principles. But when you are dealing with data protection authorities, and especially in a breach context, as a controller, you should remind yourself that you are the one who need to assess whether or not you are facing a reportable data breach. And you are the one that have or might have to defend your choice later on. Hence, seeking guidance from the authorities on that position, so on whether or not you face a reportable breach, might not just be the right thing to do. Indeed, there are no off-the-record conversation with your authorities. What you tell them is on their files. That doesn't mean that no discussion or conversation with DPAs is useful or that you should always avoid speaking to authorities, but probably that there is a timing and a way for interaction with DPA to run as best as possible. For example, interacting with your DPA following an initial notification on things like timing and expectation for the notification in phase is probably something you really need to do and go, rather than trying from the outset to reach out to them. In the same vein, we have seen that some DPA have promoted hotlines for data breach reporting, so really asking for organization to call a dedicated help desk or line for reporting a data breach. You probably need to do that with caution, especially if you keep in mind the fact that there are no off-the-record conversation with them. Who will you be sending for taking that call? Will it be your GC, someone like your chief of information officer, or some security expert? And how will you prepare themselves to answer tough questions that might be raised by authorities? Therefore, the kind of lesson there is wherever you can, and as long as those portals for reporting of a breach are working and available, probably use forms rather than calling authorities. And finally, in that kind of discussion and interaction with authorities, what we also learned, and that probably isn't such a surprise because it's following the path that we saw under the directive, is that there is an uneven responsiveness rate amongst the data protection authorities. And some of those authorities are taking steps that are even not provided for by the regulation. As an example that we faced was that a data protection authority sent inspectors to processors, whilst a breach was happening, although you can probably think that initially those kind of investigations should be targeting the controller who had to report the breach. So lesson 3 now. A data breach is a test for your election of your lead supervisory authority. As you know, when you are dealing with cross-border processing activities, EU-based controller might designate a lead supervisory authority. This requires proper documentation to be in place, supported by ad hoc assessment. And we know from experience that it's not always easy to assess which authority will play the role of the lead supervisory authority. We should also remind ourselves that LSA is not available to all controllers because the regulation clearly excludes non-EU based controller from that framework. This is very relevant in a breach notification context because as controller, when you can rely on LSA, you only need to notify that specific LSA and not notify each and every possible authorities concerned by the breach. What we have learned there is that controllers tend to stand behind the choice they made or the election they did, or they think they made, because what we saw is that a lot of the questions we raised to clients in that context just are left unanswered, and that very often clients just stick to what they think they have elected or applied for as LSA. It's important to keep that in mind and sometimes to refresh documentation on LSA, because in case of doubt as to who the LSA is, the Working Party 29 breach guidelines mandate you to then go for multiple notification if you want to protect yourself. We haven't seen so far elections of LSA being challenged by the different data protection authorities, even though they have the power to do so. And for example, one specific data protection authority might just launch its own investigation and not rely on the one-stop shop concept. But that so far hasn't yet happened.
So, lesson 4, notify data protection authorities is sometimes uneasy. The General Data Protection Regulation requires controllers and processors to have technical and organizational measures in place to ensure an appropriate level of security of personal data. They should have the ability to detect, address, and report data breaches in a timely manner. In particular, when a personal data breach happens, it is the controller's responsibility to notify the authority without undue delay, and in any case, within 72 hours. In certain circumstances, the breach should also be communicated to data subjects, and we will see later when this is required. Supervisory authorities in the different member states develop their own notification forms that are available online. Such forms require controllers to disclose specific information about the breach. The information to be provided can significantly differ from one authority to the other. They usually include a description of the breach, information on the types of personal data involved, who are the data subjects concerned, and what measures were taken to mitigate the risks. In many cases, providing this information within 72 hours deadline may not be an easy task. This is even more the case when data breaches happen at processor level. In this context, processors play a central role in assisting controllers in dealing with the breach and mitigating the risks. When you are a controller, in order to fill in the breach notification form appropriately, you will have to rely on your processors to receive accurate and granular information about incidents. However, you should always keep in mind that you retain overall responsibilities in the notification process. To avoid last-minute issues, you should ensure that the data protection agreements with your processors include details on how the processor will provide assistance in case of a breach. Relying on the data processing agreement template proposed by your processor may not always be a good strategy, and processor-friendly clauses should be identified and negotiated. Our experience in assisting our clients in dealing with data breaches shows that it is essential that contracts between controllers and processors provide details on how the processor will notify the controller, which types of information will be provided, and the timeline the processor is expected to meet. When you are a controller, having a merely general clause stating that the processor will assist you in dealing with data breaches will unlikely enable you to manage the breach and effectively comply with your GDPR obligations. For instance, it would be recommended to include a deadline for the notification of the breach, such as 24 hours, and to specify the type of information the processor should provide. This should include a description of the nature of the breach, including the categories and approximate number of individuals and personal data records concerned, and the description of the measures taken to address the personal data breach, including, where appropriate, measures to mitigate its possible adverse effects. When a breach happens, controllers should also review the information provided by the processor and should not just rely on their assessment, but carry out their own one. In a recent data breach we worked on, involving an hospitality software, we realized how the processor encountering the breach was actually trying to bargain on controllers to try to avoid communication to data subjects or to limit the information disclosed to them, in a way to mitigate its own exposure and potential reputational damages. Lesson number 5 relates to communication to data subjects. Controllers are required to inform the affected individuals of the breach without undue delay when the data breach is likely to result in a high risk to their rights and freedoms. This is generally the case when the breach could lead to physical, material, or non-material damages, such as discrimination, identity theft or fraud, and financial losses. However, the assessment must be carried out on a case-by-case basis, taking into account the specific circumstances of the breach. Given the tight timeline for communicating to the affected individuals, drawing a line between what is a risk and what is a high-risk breach is not an easy task. This is why controllers should define a methodology for assessing the risks related to a breach, which should be part of their incident response plan. In other words, it's good that you have a breach management plan, and it is even better if the plan includes a methodology on how you will assess the breach, that the breach is high risk. In order to carry out this assessment, controllers may rely on tools and existing methodologies. The Working Party 29 provided guidance on the topic and referred to the European Union Agency for Network and Information Security, ENISA, recommendations for a methodology of assessing the severity of a breach as a useful guidance. This may be a good starting point to design your breach management response plan. However, experience shows that the methodology proposed by the ENISA should be balanced with what is the main objective and rationale of GDPR communication requirements to affected individuals, which is to provide specific information about steps individuals should take to protect themselves from any negative consequence of the breach. And this may turn out to be an easy exercise. While GDPR requires companies to communicate to individuals located in the European Union, it is often the case that data subjects located outside of the European Union are in the same way concerned by the breach. Experience shows that it is difficult for organizations faced with communication requirements in the EU to assess whether or not to communicate to all affected individuals wherever they are located, with some breach notification forms of supervisory authorities even requiring controllers to provide such information. Some level of complexity may be added in this context when the breach happens at processor level. As explained before, experience proved that processors may be quite reluctant in providing the right level of details and assistance to controllers, and may push not to communicate to data subjects or to limit the information provided to them. However, detailed information about the breach are necessary for the controller to carry out the risk assessment in a proper manner. This is why, if you are a controller, you should always keep in mind that you are the one responsible for communicating with individuals, and you should not get caught by processor-driven communication.
As mentioned initially, let's close our section with two bonuses. The first one is that you probably need to be also careful of some of the subject access requests you are getting, because what we have seen is that such requests might, if they are not genuine, be just the entry doors for a data breach. The second lesson that is also important to get as a bonus is that typically breach happens or are first reported or noticed internally on a Friday. As you know, today we are Thursday. That doesn't mean that we are expecting to speak with many of you tomorrow, but just be cautious and meaningful that indeed it's a Friday thing. And without further ado, let me now pass the word to Oliver and Bjorn for DPA experience.
Thank you very much, Charles and Arletta. This is Oliver Jaros, and along with Bjorn Volmuth, we're going to be talking about negotiating data protection addenda with third parties, and we'll be discussing some of the unintended effects of doing that. Over the last year, there has been an enormous amount of effort that has gone into both controllers and processors trying to renegotiate their relationships with one another with the GDPR requirements in mind. In this part of the webinar, we'll be talking about our experiences, looking at both the customer perspective and the service provider perspective, trying to negotiate these data protection terms and data protection addenda. Broadly speaking, the requirements that we've seen being negotiated fit into three categories. Those that are required under Article 28, that is, those requirements that controllers must seek to impose on processors, and then the direct obligations that controllers and processors have under the GDPR. So looking at the Article 28 obligations, in the main, it's been customers looking to impose on service providers as processors obligations such as a requirement only to act on the controller documented instructions, requirements around security, and then some of the other obligations under Article 28, such as the requirement to keep data confidential, to return or delete personal data at the end of the engagement, and also the right to conduct an audit and to have control over the appointment of sub-processors. Some of the direct obligations that we've seen customers and service providers negotiate include things such as the requirement for a controller to keep a record of the personal data they have, the requirement for a controller to have a DPO appointed where they're doing processing that requires that, the requirement to conduct a data protection impact assessment where they're obliged to do that, providing fair processing notices under Article 13 and 14, obtaining consent where that's required for their processing activities, and then liaising with supervisory authorities and data subjects, and so on. Processor obligations include keeping a record of the processing activities being undertaken on behalf of the controller, appointing a data protection officer where they're conducting processing activities that require that, and then the obligation to notify a controller of a personal data breach where that occurs, or where a controller's instructions infringe law. On this slide, I will be examining the service provider's perspective when negotiating data protection terms or data protection addenda. In most cases, these service providers will be receiving personal data from a customer as a processor, and so will have the Article 28 requirements to think about, as well as their own direct obligations. But in some situations, such as in cloud services, service providers may in fact be controllers, and that of course adds an additional dynamic to these types of negotiations. Generally, though, the typical points of concern that we've seen for service providers in the negotiation tend to fit into 5 main categories. Firstly, that the processing that they're being asked to conduct, or are going to conduct, complies with the law. And where a service provider is a processor, the responsibility for ensuring that the processing they're being asked to do on behalf of the controller sits with the controller to make sure that the processing they're being asked to do complies with the GDPR and other laws. So that is a typical area of concern that a service provider typically seeks comfort from the customer about. Secondly, there is of course a lot of discussion around security, the security that the service provider will take when processing the personal data and also providing that personal data to additional third parties, such as sub-processors. There will be a lot of discussion around who is going to ensure that the personal data remains secure and whether the personal data security is in fact appropriate for the purposes concerned. And that is an issue that a service provider will take a lot of care negotiating. The third issue that we've seen being negotiated quite extensively is control and consistency over terms that a service provider has with respect to their downward chain of sub-processors, and also control over a right that a customer might have to audit them. Typically, a service provider will have a myriad of different relationships with other service providers that it uses, and it will have lots of different customers, and they'll all want to impose their own specific contractual clauses on the circumstances under which that service provider can appoint sub-processors and the rights that that customer will have to audit their behavior and their compliance with the GDPR. And that's mainly because under Article 28 there is this requirement for a controller to ensure that the same data protection obligations are imposed by a service provider on its sub-processors. And of course there are then further requirements that have to be complied with around only appointing sub-processors where the controller has given its consent, and there is some general language about the audit rights that a controller must have. So making sure that the service provider retains control over its supply chain and the circumstances under which a customer has the right to object to the appointment of sub-processors and the right to conduct an audit, to make sure the terms are consistent between all of its customers, is very important for a service provider. And then, of course, there are the circumstances under which the service provider has to notify a controller of a personal data breach. Typically, the issues that are negotiated here are around timing and, in some circumstances, the threshold for actually making that notification with respect to whether it impacts the controller's personal data versus other personal data that the service provider might be processing. And then finally, liability is of course a very important issue for service providers to consider when they will and will not be liable for different types of processing activities. And importantly, the security that they take with respect to personal data and any liability they might have for a personal data breach. So what trends have we seen when negotiating these types of provision? Well, we've seen a disclaimer of liability and suspension rights being sought by service providers where processing doesn't comply with the law. Typically, a service provider will be looking to a customer to ensure that it has the rights it needs to allow the service provider to process the personal data that it is providing to that service provider. And where the controller doesn't have those rights, or hasn't sought the consents, or hasn't made the notices that it needs, that is a situation in where the service provider will try to either exclude any liability for processing that it might conduct, or also give itself a right to suspend its processing, where that becomes clear until the controller has remedied that situation. So that is a trend that we're seeing from that point of view. With respect to security, we're seeing some service providers say that although they will ensure the appropriateness of security that they take with respect to certain uses of personal data that they might be appointed to conduct, they cannot provide necessarily a blanket comfort that the security measures they're taking are appropriate for all of the processing activities that they may conduct or the controller may ask them to conduct. So typically service providers are looking to controllers to satisfy themselves that the security measures that the processor is taking will meet the controller's requirements. With respect to control over the supply chain, we are seeing many service providers take the view that although they will provide visibility to controllers about the service providers, the sub-processors that the service provider uses, they will not necessarily allow a controller to have a real say over which sub-processors they use. By that I mean have advance notice of the sub-processors they're going to use, and a right to object, and a right to insist that alternative sub-processors are appointed in their place. Typically we see service providers seek a general consent to the appointment of sub-processors with visibility over who they appoint, and a limited right to object, which may only give a customer a right to terminate or result in a change control situation where the cost of the service becomes more expensive not to use that particular sub-processor. And with respect to the audit rights, we're seeing service providers take, in the main, a relatively limited approach in that they are predefining the audit rights that a customer will have in terms of number of audits they might conduct and the scope of information that will be provided. And of course, taking a fairly consistent approach with respect to the costs of the audit, in that the customer, in the main, will have to bear those costs. With respect to personal data breaches, we're seeing service providers take an approach where they are resisting specific time limits being imposed on them as to when they will provide information about the personal data breach. Often customers will insist on 24 hours, 48 hours, or another range of hours, where a service provider will have to tell the customer, after having become aware of a personal data breach, trying to define what undue delay actually means. But we see a number of service providers try to resist those specific time limits that customers are trying to impose, and are in some cases providing a blanket time limit for all of their customers to make sure that all customers are being treated in the same way. And then finally, we're seeing a real re-evaluation of the liability provisions that service providers have previously been offering. Clearly, service providers have been contacted by many customers seeking to renegotiate the liability provisions with respect to things like personal data breach, events, and other types of breaches of the General Data Protection Regulation, and we've seen service providers trying to narrow the circumstances in which they may in fact be liable for a personal data breach, for example, only where they're in breach of their own security policy, and also trying to limit the types of losses for which they might be liable. So that is an overview of the trends that we're seeing from the service provider's perspective, And I'm now going to hand over to Bjorn, who's going to talk about the customer's perspective.
Thank you, Oliver. This is Bjorn Vollmuth from Mayer Brown's Frankfurt office, and I would indeed like to shed some light on the customer's perspective now. So here are some typical points of concern for customers and respective trends in the negotiating stance of customers that we see in our day-to-day practice. So first of all, we quite regularly see clauses whereby the customer's right to object to the use of a new subprocessor is in some way limited. So for instance, the DPA might contain a list, an exhaustive list of reasons for which the customer can object to the use of a new subprocessor, or more generally, the DPA might stipulate that the customer may only object for an important reason. Now, it goes without saying that the objection should not be random, but in any event based on objective, on factual reasons. But further limitations need to be verified very carefully and are often declined by customers in practice. Now, the preferred consequence of a valid objection to the use of a new subprocessor from a customer's perspective would of course be that the processing shall continue without using the relevant subprocessor. However, customers need to be realistic. They need to bear in mind that usually they will not be the only customer of that service provider, but rather one among hundreds. So a more realistic outcome in practice, if the objection cannot be resolved, would be to agree, for instance, that either side shall be entitled to terminate the DPA and the underlying service contract either in their entirety or at least partially to the extent that the services shall be rendered by the subprocessor that the customer has objected to. Next up, we also see limitations on the right of the customer to issue instructions. The DPA could be phrased along the lines, customer may give instructions. This DPA and the statement of work constitute the customer's complete instructions. Any further instructions need to be agreed separately in writing. While such a limitation may be acceptable in cases of very simple, very straightforward processing operations, it is usually declined in practice by customers. And that is, of course, owing to the fact that the customer is the controller, and as the controller, it is responsible for the whole processing operation, and therefore needs to be in a position to give processing-related instructions if needed. Instead of such a limitation, the parties could agree that a service fee shall become payable in case the provider needs to comply with an obligation that goes beyond the scope of the agreed services. As regards the description of the technical and organizational measures, or short TOMs, of the service provider, we often see a mere reference to the provider's website in the DPAs. That is usually not acceptable in practice, because that would mean that the customer is dealing with a moving target, because obviously the service provider could change the website at any point of time. So instead, customers will usually insist that the current status of the TOMs at the point of time the DPA is entered into shall be documented in an attachment to the DPA. Another hot topic that Oliver already covered from a provider's perspective is the deadline for personal data breach notifications. I can confirm that there is a tendency among customers to insist on short and very short deadlines, such as 48 hours or even 24 hours after the incident. From our experience in practice, that is not necessary and not feasible, because an unreasonably short deadline will without a doubt lead to a lot of false positives. In other words, it may appear that there has been an incident, so the provider needs to notify the customer, but then given some more time to investigate the facts of the case, it may turn out that, as a matter of fact, there was no incident at all, or maybe there was an incident, but it was a very minor one, which did not have any consequences whatsoever. So from our experience, an unreasonably short deadline leads to extra work and a lot of back and forth that can be avoided. Also, controllers need to bear in mind that their deadline for notifying the affected data subjects and the supervisory authority only commences upon receipt of the notification from the provider, not upon occurrence of the incident itself. Second to last item on my list for today are backup concepts or deletion schedules of service providers. Now, as you know, personal data is to be deleted or returned to the customer at the end of the service contract as per the customer's request. Service providers tend to restrict this obligation by stipulating that personal data is to be deleted at the end of the service contract, subject to the provider's deletion schedule. And when you start questioning that and you start looking into that, it often turns out that the provider is, from a technical standpoint, not even capable of deleting an individual customer's personal data. And that is owing to the fact that the backup concept is not customer-based. So, in other words, there is not a single backup tape per customer, but rather backups are done on a time frame basis. So any given backup tape will contain various personal data pertaining to various customers in that particular time frame. And as a consequence, the provider is just not able to separate personal data of customers and to delete it accordingly. While this is obviously not ideal from a GDPR perspective, customers do seem to understand that such technical impediments cannot be ignored in practice. So from our experience, customers are usually willing to try to find a reasonable compromise in order to deal with this. And last but not least, the liability cap. I can confirm from our experience that there is a tendency among customers to try to renegotiate liability caps in light of the increased fines under the GDPR. That is all from my end, and I'm handing over to my colleague, Lei.
Thanks, Bjorn. This is Lei Shen from the Chicago office. For those of you who have been able to escape the requirements of the GDPR so far by not processing EU personal data, you may soon find yourself facing other GDPR-like laws. The GDPR has inspired a number of similar laws in other countries, including Brazil and California here in the United States, which were both passed recently. Not all of these laws mirror the GDPR, though. There are some key differences. We will cover the requirements of these new laws and compare them to the GDPR, first starting with California. California's governor signed into law the new California Consumer Privacy Act, or CCPA, on June 28th, and the law is considered by many to be the strongest, most aggressive privacy law in the United States. The CCPA took a rather non-traditional route to be implemented. The law started as a ballot initiative launched by a San Francisco real estate developer who was concerned about data privacy. The real estate developer spent nearly $3.5 million of his own money to place the initiative on California's November ballot and agreed to withdraw this initiative after lawmakers moved very quickly to pass a compromise bill. The resulting bill is very similar to the original ballot initiative, but not as strict in certain areas. Most significantly, legislatures preferred the bill to the ballot initiative because it provides more options for refining the law's requirements down the line. A ballot initiative, on the other hand, if it had been approved, would have only been able to be changed through another ballot initiative. The CCPA is similar to the GDPR in some respects, particularly regarding disclosure requirements and subject access rights. Substantively, however, the GDPR contains a number of provisions that are absent from the CCPA, and the CCPA also contains some obligations that aren't required by the GDPR. The CCPA impacts a broad number of businesses. Unlike existing state and federal privacy laws in the United States, which tend to focus on a specific sector or type of personal information, the CCPA applies across industries into a wide range of consumer information. The CCPA covers for-profit companies doing business in the state of California that satisfy one of the following criteria: has annual gross revenues of $25 million or more, obtains personal information of 50,000 or more California residents, households, or devices annually, or derives 50% or more of its annual revenue from selling the personal information of California residents. The law covers companies doing business in the state of California. Simply entering into repeated and successive transactions in California is considered to be doing business in California, even if those transactions are conducted remotely and online. As a result, the CCPA has a potential extraterritorial application, like the GDPR, making it difficult for companies that don't have a physical presence in California to avoid complying with it. The CCPA's definition of personal information is very broad. Before it was amended, the definition was even broader than the corresponding definition under the GDPR. Specifically, the original CCPA definition of personal information was any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with the particular consumer or household. This means data could be protected even if it didn't relate to a single individual, as long as it could be linked to a household. A consumer is also broadly defined as a natural person who is a California resident. Accordingly, unique identifiers, biometrics, geolocation data, browsing and search information, and inferences drawn from such personal information that are used to create a profile about a consumer are all protected as personal information under the CCPA. The CCPA introduces a number of rights for individuals with respect to their data, some of which are similar to the GDPR. For example, the CCPA gives consumers the right to request that a company disclose the types of information that it has collected about them in the past 12 months, as well as certain information regarding what the company does with the data and the categories of third parties with which it shares the data. Consumers can make such requests no more than twice a year and at no charge to them, and companies must respond to verifiable requests within 45 days, which can be extended. The CCPA also gives consumers the right to request that a company delete their personal information, subject to certain exceptions. The CCPA provides consumers the right to opt out of the sale of their personal information. And for anyone under 16 years of age, companies must obtain opt-in consent from them or their parent. Businesses must have a clear and conspicuous link to "Do not sell my personal information" on their homepage and on every page that collects personal information, that gives consumers a way to opt out. Now contrast this to the GDPR, where under certain circumstances, data subjects can opt out of their data being sold or object to the practice, but they don't have an explicit right to opt out of selling their personal information. Importantly, the CCPA prohibits companies from discriminating against consumers for exercising any of these rights. For example, you can't deny goods and services, charge different prices, or provide a different level of quality of goods and services if an individual exercises these rights. However, companies can offer higher tiers of service or product in exchange for more data as long as they're not unjust. This may enable companies to offer discounts on products or services to consumers who will allow certain uses of their data. But there is uncertainty regarding how the California Attorney General will interpret and enforce this restriction. Just as with the GDPR, non-compliance with the CCPA has the potential to be very costly. The CCPA is enforced by the California Attorney General, and any person, business, or service provider found to be in violation of it could be penalized up to $7,500 per incident, which could be per consumer or per record. In addition to enforcement by the California Attorney General, the CCPA also provides individual California consumers with a limited private right of action, specifically in connection with the breach of non-encrypted or non-redacted personal information resulting from a violation of reasonable security practices and procedures. Late last month, California lawmakers passed an amendment to the CCPA, which is now with the governor for consideration. The amendment provides largely technical and clarifying changes, although it also contains several more substantive changes, including some changes that were sought by the tech industry. One of the more significant changes to the CCPA is that the amendment revises the definition of what constitutes personal information. Specifically, the amendment revises the definition to make clear that data is considered to be personal information if it identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. As a result of this change, data types such as IP addresses, purchasing histories, and geolocation information will no longer be deemed to be personal information. Instead, they will become personal information if they can be associated with a specific consumer or household. Another significant change is that the amendment extends various time frames. Specifically, the amendment extends the deadline for the California AG to draft and adopt the laws implementing regulations by 6 months, from January 1st, 2020 to July 1st, 2020. It also prohibits the California AG from commencing enforcement actions under the CCPA until 6 months after publication of the implementing regulations, or July 1st, 2020, whichever comes first. The amendment also expands the carve-outs for information subject to the Gramm-Leach-Bliley Act, or the Driver's Privacy Protection Act. Previously, the law only exempted GLBA and DPPA data where the CCPA was in conflict with those statutes, which led to concerns that such a conflict could either be non-existent or very narrow. Now, data collected, processed, sold, or disclosed pursuant to the GLBA, the DPPA, or the California Information Privacy Act are exempt from the CCPA's requirements. The amendment also adds exemptions for certain healthcare providers, making it clear that the CCPA does not generally cover information collected by institutions that are governed by HIPAA or the California Confidentiality of Medical Information Act. The amendment also expands the category of exempted PHI governed by HIPAA and high-tech to include PHI collected by both covered entities and business associates. The original text did not address business associates. Although the amendment does clarify a number of provisions in the CCPA, a number of other ambiguities in the law remain and will need to be addressed in future legislative sessions. While the CCPA is similar to the GDPR, unfortunately, even companies that are compliant with the GDPR will still need to make further changes to be compliant with the CCPA. Similarly, compliance with the CCPA will not ensure compliance with the GDPR. However, companies can leverage any work done to comply with the GDPR to reach compliance with the CCPA. For example, revising online privacy policies, data mapping, developing a process for addressing subject access requests, and revising agreements with service providers are all projects typically needed to reach GDPR compliance and can be used to reach compliance with the CCPA. However, there are still key differences between the rights granted by each law that will require companies to closely evaluate each law and conduct a gap analysis to make sure they comply. As the first state to adopt a state data breach notification law, California has often been a trendsetter in U.S. privacy law, and it's likely the CCPA will start a wave of similar laws in other states and possibly the federal government. Brazil enacted its Data Protection Law, or LGPD, in August 2018. The LGPD was inspired by and is very similar to the EU GDPR, and is more similar to the GDPR than the CCPA. The LGPD's key provisions closely mirror those of the GDPR, including extraterritorial application and significant fines. The LGPD will come into force in February 2020, giving companies 18 months to get ready. The LGPD applies to all processing of personal data by private entities, individuals, and the government. If the data is collected or processed in Brazil, or if the processing is for the purpose of offering or providing goods or services in Brazil. This provides a law with extraterritorial applicability, similar to the GDPR. As a result, companies not operating in Brazil may be impacted. And similar to the GDPR, the LGPD defines personal data broadly as information related to an identified or identifiable individual. The LGPD also defines a subset of personal data as sensitive data and provides special protections for it. Sensitive data is personal data related to one's racial or ethnic origin, religious and political views, union, religious, philosophical, or political affiliations, health, sexual, biometric, or genetic data, similar to the special categories of personal data under the GDPR. The LGPD requires that the processing of personal data only be carried out where there is legal basis for the processing, which may include where the processing is done with the consent of the data subject, necessary for compliance with a legal or regulatory obligation, necessary for the fulfillment of an agreement, or necessary to meet the legitimate interest of the data controller or third parties. And this is very similar to the GDPR. Unlike the GDPR, however, the LGPD also lays out some additional, more specific bases, such as the protection of health in a procedure carried out by health professionals and the protection of credit. Non-compliance with the LGPD can result in significant fines, although not as high as those under the GDPR. Under the LGPD, violations can result in fines up to 2% of the company's gross revenue in Brazil in the previous year, although this is limited to 50 million reais per violation, or approximately $12.9 million US. The penalty is also calculated based on Brazilian revenue only, not global revenue as under the GDPR. The LGPD also introduces a number of rights and obligations that are similar to the GDPR, including data subject rights, security requirements, the requirement to appoint a DPO, and data breach notification requirements. More significantly, though, the LGPD also has cross-border transfer restrictions similar to the GDPR. This means that transfers of personal data are only permitted either to countries that are deemed by the Data Protection Authority to provide an adequate level of data protection, or where standard contractual clauses or other mechanisms approved by the Data Protection Authority are used. This concludes today's webinar on GDPR, Lessons Learned from the First 100 Days. We hope the information shared today was useful. Thank you so much for your participation and have a great day.